Hello everyone, welcome to Excellence IAS Academy. Recently, petition have been filed in Supreme Court with respect to complete ban from contesting elections of persons who have been conducted under criminal offences. In this context, we will discuss disqualification of legislators and also other persons from contesting elections or holding membership in parliament and also state legislations. So let us discuss. Disqualification of legislators have been mentioned in Constitution and also mentioned in Representation of People Act of 1951. Under Constitution, any member of the parliament or state legislature can be discussed on the mind of unsound mind if he is not a citizen of India and also if he holds post of profit. These are the major reasons on which any parliamentarian or state legislator can be disqualified. Under Representation of People Act of 1951, series of offences have been added, but we will discuss some of the reasons why any persons can be disqualified from holding post in parliament and also state legislature, especially section 8 of the RP Act 1951. This section oftenly discussed with respect to disqualification of members. Let us discuss this section 8. Section 8 clause 1 lists some of the criminal offences under which any member of the parliament or state legislator can be disqualified from that post. It's including promoting enmity on the ground of religion, race, place of birth, residence, as well as language. On these 5 grounds, any member or any person, if he promote enmity, he can be disqualified from that post. And also it lists rape and cruelty towards women, hate speech means any speech that creates enmity between different sections. This can be considered under section 8 subclause 1. Other related such election related offences like booth capture, removing ballot papers, and other very important criminal offences including terrorist activities, holding any membership in any banned organization or unlawful organizations. These are the activities which can lead to disqualify of any membership in parliament and as well as state legislature according to section 8 subclause 1. And section 8 subclause 2, this says that any member also can be disqualified if he practices dowry, he promotes dowry, if any member go for adulteration of food and any promotes such adulteration of food, and also if any member who promotes hoarding and profiteering. If any member promote these activities, also involved in this kind of activities, he can be disqualified from the post of parliamentarians and also state legislatures. And section 8 subclause 3 says that any offences other than section 8 subclause 2 and section 8 subclause 1, if any member commit these crimes, he will be automatically disqualified. Other than these crimes, if any member commits any offences, if he sentenced not less than 2 years, he can be disqualified from holding that post or holding any membership in parliament and also state legislators. He is also not disqualified from this period, but also 6 years after the release from the prison. So together this, it may be 8 years, it may be 9 years, it may be 10 years, whatever may be the period. But section 8 subclause 4 says that if any MLA or MP is convicted, he has a 3 months period, but he can be continued as MLA or MP up to 3 months after he have been convicted. Why? Within these months, he can be approach High Court. Means If any MLA MP can be disqualified in trial court, right? Trial court. After that trial court, he can approach High Court within this 3 months period. But in Lily Thomas case in 2013, Supreme Court struck down this section 8 subclause 4. Why? Supreme Court had said that there is no need for the 3-month trial period. He can apply after become convicted in any offense. So it goes against the mandate of the Constitution. Because of this, Supreme Court struck down this section 8 subclause 4 and this 3-month period now cancelled. And now any person who is convicted under any offense, he is disqualified from that conviction date. But recently, petitions filed in Supreme Court. If any person convicted under any crime, if he is sentenced not less than 2 years, he should be completely banned from contesting election and become parliamentarian or state legislator. Why? Supreme Court argued that this lawmaker, this convicted person is a law breaker. So if he is lawbreaker, if again becoming lawmaker, how this could be justified? So because of this, Supreme Court is also thinking and also questioned the central government why this is happening. The lawbreakers are also becoming lawmakers in this country. So there should be a complete ban. So Supreme Court hearing this case and there will be a verdict on this. So we will look for that particular case. So thank you for watching the video.